Hello, students. Today we're going to talk about pretrial motions. We're going to speak about pretrial motions as it relates to motions to suppress in this video. And in class, we're going to go into more depth about motions in limine. All right. Okay, there we go. So what is a pretrial motion? A pretrial motion is just a device and a way that you request that an order or a decision be made by the court. A motion is an application for an order or decision. It's a formal definition. It can be oral or in writing. Many motions in criminal law are oral, but there are some very important motions, like a motion to suppress, that needs to be made in writing. For federal criminal law, almost all of the motions are done in writing unless the court permits something else. Once a motion is filed, the other side gets to file a response. So when is it filed? Motions can be filed at almost any point during litigation. So the generic term for any motion filed before trial is a pretrial motion. This would include motions to dismiss, motion to suppress, motion for summary judgment, motion to compel discovery. Any side can file a motion. It can be the state or government or the defendant. The defense tends to file more motions than the state does. Now, the governing rules are based on the rules of procedure and by case law. So why do we bother filing motions? Well, one reason to file motions would be to persuade the court, because you're looking for a court order. You want the court to do something. You also want to educate the court about your position. You want to inform opposing counsel of your position. And you also want to show the client that you're actually working on their behalf. Now, this is a little bit of a reminder of legal research, but here are the typical parts of a pretrial motion, memo, or brief. Now, there is no standard set way because it's all going to depend on the local rules of court. But generally, all of your motions should include a caption, a title, an introductory statement, summary of the facts, the issue, argument authorities, conclusion, a signature block, a certificate of service verifying that you did in fact serve your opponent, a proposed order. Judges are very busy. You need to write the order for them to sign, and any affidavits and evidence that need to be attached. Let's talk about the caption first. Excuse me. The caption is where you're going to identify which court the document is filed in and the division. It's also going to have each party's name, designation, plaintiff and defendant, and the docket number. If you look at the sample briefs that I've already uploaded on Stanley, the very top of every brief is the caption information. The title is also controlled by local rules. It's important to be descriptive in the title. Who actually is filing the document? Try to name them as specifically as possible. Don't just say defendant. Say defendant Smith memorandum in support of motion to dismiss plaintiff's complaint, or plaintiff Bell South's memorandum in support, and so on. But try to be descriptive. Once you have the caption, there should be a sentence or two after the title. This brief sentence is your opportunity to identify yourself, who you represent, what you're filing, and what you want. So a traditional way to do this would be comes now defendant Abe Lincoln by and through his counsel of record, Najee Rutledge, who filed this motion for blah, blah, seeking blah, blah. So it can be one sentence. That's kind of long and rambling, but you get the point. It needs to just hit those high spots so the reader knows, usually the judge, ahead of time, what relief you're seeking and who you represent. Another example, defendant Nancy McDonald moves this court pursuant to Federal Rule of Civil Procedure 12b-6 to dismiss the complaint brought by Nally Jones for which failure to state a cause of action upon relief may be granted. Your introduction, which is a separate section from those one or two sentences, it can say introduction or introductory statement, but it should be something that grabs the court's attention. And if you're the moving party, you want the court to know why the motion is necessary and why you should win. If you're the opposing party, you want to be able to argue why the motion that was filed is improper, whether it was untimely or unnecessary, and even if it's not, why you should still prevail. The conclusion, also known as the prayer for relief, is usually a short statement just reminding the court of the relief that's being sought. It can be a conclusion paragraph, a summary statement of the argument, and then the prayer. My conclusion sections are usually very brief and to the point. They usually will say something like this: for the foregoing reasons, or for these reasons, plaintiff, the state, the government respectfully request that the court grant these or deny the defendant's motion to suppress. Your signature block under the local rules in Texas need to include your name, your address, your phone number, fax, bar number. The certificate of service is a document that just verifies that opposing counsel received a copy of the document. It's usually required every time you do any kind of court filing. So let's get in the habit of doing it now, including for your upcoming assignment. There are samples available for the formatting. It usually says something along the lines of, I hereby certify that a true and correct copy of the foregoing document was delivered to opposing counsel via courier service. But something that just verifies that you gave the opponent a copy of the document and you sign it. And then the proposed order, something else that a lot of attorneys, especially new attorneys, forget. Always submit a proposed order when you are practicing in state court. Judges are used to just signing that order. They don't have time to stop and draft an order for you. So if you want the order signed, make sure you draft a proposal. So now that we've talked about the mechanics of what goes into a pretrial motion, let's go into more nitty-gritty. There are literally countless of possible pretrial motions available, including in criminal law. Now, first I want to talk about being mindful of the timing. I'll turn the volume up.
All rise. Be seated.
I'll hear from the defense.
Your Honor, I have a motion together with a memorandum of law asking you to commute Mr. Pearson's conviction of murder in the second degree to one of manslaughter. It wasn't my intent to surprise the court. I just made this decision. I'm certainly willing to give the Commonwealth time to respond.
Your Honor, I take strong exception. If she had time to draft a memorandum, she had time to make a phone call.
To the court as well.
I'm agreeing to time now.
The motion is denied.
Well, I would like to be heard before...
If you felt your client should have been charged with manslaughter, you should have raised it before trial.
We have no right or authority to tell the Commonwealth what to charge.
So what are you doing now?
You have the right, as a judge, in the interests of fairness.
Yes, and if you asked me to consider it, maybe...
You can act without a lawyer having to ask you.
You're not fooling me, counsel. You kept this card in your deck. Go through with the trial, and if we lose, argue prosecutorial misconduct not to charge manslaughter.
That's not what I'm doing.
It is. You're looking for a free bite.
I am not looking for you to take...
The answer is no.
Hey! Can you at least read it? If you want to hold me in contempt, fine, but you have been strong-arming this case from the start. This stinks!
So this is a great example of not what to do when you practice law. Just a little comic relief there. So let's talk into greater detail about the different motions. So you can file a motion to dismiss an indictment. And when I say indictment, I'm talking about felony cases. In the state of Texas, felonies have to be, the charging instrument is an indictment, and misdemeanors, it's an information. It can be based on failure to state a claim, denial of speedy trial, prosecutorial misconduct, negligent failure to comply with Brady duties, failure to follow the court's discovery orders, a motion to suppress, motion to change venue, motion for mental exam, motion to withdraw a plea, motion for continuance, motion to produce an incarcerated witness to testify, motion to sever. The list goes on, but these are just some of the popular motions in criminal law. One of the absolute most popular one, besides the motion in limine, which we will discuss further in class, is the motion to suppress. Now, the motion to suppress is based on the exclusionary rule. Think about someone's constitutional rights being violated because of an illegal search or seizure. That's when you want to file a motion to suppress. Anytime evidence is obtained illegally, the court may find it inadmissible. Common grounds would include exceeding the scope of a lawful search, including a lawful search warrant, a confession or statement that's obtained through threats or promises, unreasonable search or seizure because of an improper search warrant, or an involuntary consent to search. Motions to suppress in real life are not very detailed. The defendant has the initial burden of proof, and I believe that they don't make their motions to suppress very detailed. It's because they don't want to show all of their cards. So most of the time when I received a motion to suppress as a prosecutor, it would say, based on this violation of the constitutional rights of the Fourth Amendment, we're filing this, the end, and nothing else. And in that case, some of the more involved judges would ask or insist that the defense be more specific, or I would just pick up the phone and say, okay, what are we looking at? Because sometimes it's something that you can work out, sometimes it's not. Since the defense is filing the motion to suppress, they have the burden. The first issue is standing. Did they have a reasonable expectation of privacy in the place to be searched? You can't raise someone else's expectation of privacy for them. So do they even have standing to contest? The moving party has to produce evidence that defeats the presumption of proper conduct. What does that mean? In the law, including Texas law, there is a presumption that searches conducted under a search warrant are reasonable, right? Because a magistrate has already reviewed the probable cause statement, so it probably was a lawful search. And on the other hand, if a search is conducted without a search warrant, without a magistrate reviewing probable cause, then there is a presumption that it was unreasonable. So if there is a search without a warrant, then we're already talking about it's already, presumed unreasonable. The defense would begin and first establish that there was no warrant involved. In real life, oftentimes you'll see the prosecutor try to jump the gun and say, we stipulate that there was no warrant and we call officer so-and-so. Now, a good judge will not let this happen. What the prosecutor is trying to do is have control of their police officer, because they don't really want their police officer on the stand to be cross-examined right away by the defense. And sometimes if you stipulate quickly enough, some judges will just let you run with that case. The proper thing is to say, no, it's the defense's motion. The defense has the burden, and that really should settle it. If the search was with a warrant, then the defendant has the burden of showing the warrant was invalid. Anytime a warrant is involved, it is the prosecution's responsibility to make sure a certified copy of that search warrant and the probable cause statement that was filed with the clerk's office is available. If there's no warrant, the state has that burden of proving that the search was still reasonable, even though a magistrate never had a chance to look at the probable cause statement. So I mentioned standing. The defendant must show that he or she had a reasonable expectation of privacy in the area or thing being searched. So if I'm let's see, if I'm a friend of a dope dealer and I'm not an overnight guest, I'm just, visiting, went by their house and there's a bust, right? And the police, maybe my timing just really is bad and they decide to execute a search warrant during that time. They come in, it's my friend's house, they have a search warrant, they secure the premises, look at everything, and they find something of mine and I'm charged with. Can I argue to suppress the evidence? Well, do I have a reasonable expectation of privacy in my friend's house? Was I ever an overnight guest? What's my relationship to the place that's being searched? What's my relationship to the defendant? All that is going to matter when it comes based on standing, because generally you cannot claim standing based on someone else's expectation of privacy. Now, if you're the prosecutor, there are a few things that you need to make sure that you do. One, verify the chain of custody of all evidence that's about to be disputed. You want to make sure you obtain certified copies. And I say that because sometimes it takes time to get certified copies unless you have had the sense enough to make good friends with your clerk. Your clerk and your bailiff can save you. Always be nice to them. And one way they can save you is if you forgot to order certified copies. Technically, your clerk can get a certified copy of something in like an hour. But the proper way to get a certified copy takes several days. So if you're about to have a hearing and you drop the ball, I hope you have a really good relationship with your clerk. Otherwise, they're just going to look at you like you're crazy, like, I'm sorry. And it's much better if they will assist you. And they don't have to assist you if you drop the ball. Now, a written response to a motion to suppress is not required if you're the prosecutor. Sometimes I'll bring cases with me and we're just ready to argue it out. And there's really nothing to respond to because most frequently the defense won't give me any details. Every single basis to justify the search that's not raised is waived for appeal. So you have got to think of every possible, even if there's a search warrant, you need to be thinking about, even if the search warrant was invalid, it's still a righteous search because of XYZ. The state has to produce the warrant and affidavit. I told you that. Hearsay is admissible in a motion to suppress. Obtaining findings of facts and conclusions of law is important. Oftentimes, the judge will just turn to me as the state and say, will you draft the proposed findings of facts and conclusions of law? And it's a pleasure to do that because hopefully I can draft it in a way that's favorable to the state. But if you're the defense, you want to have something ready as well because the judge is probably very busy and is not going to do it. They're going to count on the parties. From the defense perspective, it is perfectly fine to let your client testify at a motion to suppress because any testimony is limited to issues raised at the suppression hearing. So the state does not get to cross-examine your client on the case. So you can feel some comfort in putting your client on the stand. If the defendant does not testify at trial, then whatever happened at the hearing is completely off limits. But if you do put your client on the stand, then impeachment can still be used against them. The state is allowed to appeal suppression issues, which is very unique. Most of the times the state cannot appeal anything. Double jeopardy applies if your client is found not guilty. But there's one area, one of the few areas the state can appeal would be if the court grants the motion to suppress. Now, you will have a motion to suppress assignment. This is one of your major writing assignments for the class. It is posted in Canvas, and we will give additional details about that as we go into part 2 in class, in our live Zoom class about pretrial motions.